My name is Rob Sampson, and I'm here because I strongly oppose House Bill 7042, an act concerning implementation of the Firearm Industry Responsibility Act. In my view, this is not a legitimate attempt to increase accountability within the firearm industry. Rather, it is a calculated assault on lawful commerce, personal responsibility, and the Second Amendment. This bill dangerously expands a precedent set by the Soto v. Bushmaster case. By imposing vague, subjective liability standards, it ensures an endless barrage of lawsuits against manufacturers and retailers, even when they fully comply with the law. This is not about addressing misconduct. It is about attempting to eliminate an entire industry through legal attrition. This bill goes way beyond the advertising liability that was in Soto, creating a sweeping, undefined legal framework that would make it nearly impossible for the firearms industry to operate in our state of Connecticut. Holding manufacturers and retailers responsible for the criminal misuse of their products by third parties is a direct assault on the foundational American principle of personal responsibility. By this logic, should car manufacturers be sued when reckless drivers cause accidents? Should baseball bat companies be liable if a bat is used in an assault? Should gasoline companies be sued if their product is used to commit arson? Should hardware stores be responsible if a criminal misuses a hammer, a saw, rope, or bleach, or countless things that could be used to cause harm? This bill erodes personal responsibility and invites limitless, frivolous litigation, driving lawful businesses into the ground. This bill's language is alarmingly broad and deliberately ambiguous. It requires firearm businesses to implement quote-unquote reasonable controls to prevent unlawful use, and without defining what those controls are. It demands that manufacturers prevent basically any public safety threat, exposing them to lawsuits for actions entirely outside their control. These provisions manufacture liability out of thin air and set an impossible compliance standard. The penalties in the bill are also excessive and punitive. It allows courts to impose crushing financial penalties, far exceeding any actual harm. Worse, it forces businesses to pay the legal fees of those suing them, encouraging frivolous lawsuits and turning the legal system into a bludgeon against lawful and legal enterprise. Beyond being unjust, this bill is counterproductive to public safety. Studies consistently show that lawful gun ownership reduces crime. I submitted a number of examples in my testimony, but by crippling the firearms industry and restricting access to legal gun ownership, this bill will have the opposite effect of its stated intent. It will increase crime by making self-defense less accessible. In my view, this is part of a broader agenda that has already weakened Connecticut's criminal justice system. Instead of holding criminals accountable, this bill shifts blame onto law-abiding businesses and responsible citizens.
Thank you, Senator Sampson. Senator Kissel.
Thank you very much, Chairman Winfield. Senator Sampson, great to see you, our former member. Just a couple days ago, we lost you on this committee. Our loss and the other committee's gains. But just a couple quick points. First of all, there was a nice gentleman that agreed with me from the Connecticut Citizens Defense League that we're in the top 3 as far as gun regulations. Some want to call it gun safety, but certainly we're not a Wild West kind of state by any stretch of the imagination. Would you agree that Connecticut is in the top 3 as far as highly regulated gun control states?
Yeah, Senator, I'm not entirely positive what the laws are in every one of our neighboring 49 states, but I do understand that Connecticut certainly stands out as having more gun control than other places. The legislation that I've seen just in my tenure in the legislature, in my view, has been egregious, has violated the rights of citizens. It has purposely, gone against the Second Amendment. I don't know a better way to say it than that, and not with any beneficial effect. I don't believe it has resulted in more public safety or any additional benefit to Connecticut residents, and certainly not to law-abiding gun owners who, were forced initially to have to stand in a line in the freezing cold back in the spring of 2014 to register their firearms, something that they never considered that they would have to do. They had to register their magazines, and people to this day are restricted from purchasing items that are lawful, in most of the other states So yes, Connecticut is definitely a standout as far as egregious gun control legislation.
And this next question, it may take some further research, but I can already hear the arguments from the advocates for this bill that may be on this committee saying, well, this is legislation that's passed in, I believe, 9 other states. We've received no testimony that businesses or gun sellers went out of business, that they can't afford insurance. It's just the old sky is falling arguments. And I'm just wondering if you're aware of any evidence that there's deleterious consequences, probably unintended, but maybe by the advocates that want to see no guns in America, maybe intended. But one of the things that will certainly help my arguments in opposition to this bill would be any of the negative consequences to the passage of these bills in other states. And I don't know if you're aware of anything or if you're willing to try to muster up some evidence so we have some, no pun intended, so that I have some ammunition regarding this.
Senator, frankly, I don't have any information about other states. It's something that's commonly said, oh, this is passed in, a bunch of other states. But, I mean, the fact of the matter is I don't really know if that's true in most cases, because just because you say something's passed in another state doesn't mean that the language of the bill is the same. I could make a few tweaks to this bill and improve it dramatically. I mean, just the fact that this bill effectively creates an arbitrary requirement for members of the firearm industry to establish, implement, and enforce reasonable controls without ever determining what those are. And then later comes back in the language of the bill to, put that back onto the firearm industry members that they failed to provide reasonable controls. Again, without any definition, something that opens a door, in fact, a hole you could drive a Mack truck through, in my view, to create a litigious, reaction. I think people will be suing more and more often.
Well, thank you very much, Senator Sampson. I really appreciate it. And Representative Dubitsky and Ranking Member Fishbein raised the idea of open carry. Some people would say, oh, that's, terrible. And if I saw that at, in a restaurant or a drugstore, I'd be afraid. But in many consequences, when bad things happen in other parts of the country, it's the person that had a rapid ability to use a handgun that stopped like a whole horror show of bad things happening in quick succession. And so really, what is a reasonable prevention of deleterious consequences or behavior is in the eye of the beholder in many respects, especially when it comes to guns. Guns is one of those issues, like abortion, like other things in our state and nation, that people have strong opinions on both sides of the issue. And reasonable people can take reasonable positions on either side. But certainly I could understand the concerns by the advocates if we were way behind other states, but we're not. I firmly believe we're around third and only behind California and either New Jersey or one of those other states. So thank you so much, Senator. You are one of the champions for the Second Amendment, and very much appreciate your time and testimony. Thank you, Chairman Winfield.
Thank you, Senator. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Senator. I think this is the first opportunity we've had since I've been up here and you've been up here. And
It's my pleasure.
well, I say that, Senator Kissel was talking about a loss. I think the gain, actually, is you having the ability to come to our committee, your former committee, and have this exchange. I think that is very refreshing for the process. Senator Kissel asked you about information about businesses that had gone out of business. I think it's only natural that if you let's take another industry. Let's take the vaccine industry, right, and compare it to the firearm industry. And if we say to the vaccine industry, you can't be sued, even though government forces people to use your product, even if they die, you can't be sued. And then we say to the firearm industry, you have to go through all these hoops and all of these challenges, and somebody's looking to enter one of those two industries. Naturally, you would have more vaccine people than you would in the firearms business. And, unfortunately, as we hear today, negative impact upon gun owners, negative impact upon gun manufacturers, negative impact upon gun sellers. At the end of the day, there's some people, perhaps in this room, that are saying, good. And that's unfortunate,
Indeed.
because I think that's the intent, ultimately, of a lot of these laws. Certainly, we're not safer after all of these things. If we were safer, then you wouldn't pick up the newspaper and read about a shooting in New Haven last weekend and a shooting in Bridgeport the weekend before, many times with illegal guns that are not even addressed really by this legislation. So, that's just a simple fact of the matter. And once again, I thank you for coming here today.
Can I react to your comments?
Yeah, and I wanted to ask you if you had any other points that you wanted to make to us about the legislation.
Thank you very much, Representative. And again, it's truly my pleasure to actually be able to sit in this chair across from this distinguished committee and be able to, provide testimony as an expert on the subject of the Second Amendment. Let me just say this, a couple things. We've talked a little bit about our station as far as where we stand with regard to gun control legislation nationally. I don't know if we're first. I don't know if we're second. I don't know if we're third. I don't know that it even matters. For me, there has been no discernible benefit from a public safety standpoint. I'll remember shortly after the Sandy Hook legislation was passed, maybe the next year or the year after that, I remember there was a case where someone was arrested for having a AR-15 in the back seat of a car. And I remember the Malloy administration at the time putting out all kinds of press. There was a full court press on, look at how great our laws are. We stopped somebody. They had an AR-15 and everything else. And I thought to myself, what greater proof that your series of laws didn't work? The whole idea behind the laws passed in the wake of Sandy Hook was to prevent these, assault weapons from being readily available and prevalent in our society. And here's an example of the fact that there's one in the backseat of a parking lot in downtown New Haven or wherever it was. So I don't know that these things have ever worked. In my view, gun control legislation simply, is using a bomb to drive a nail instead of a hammer. And what it does is has the impact of harming the rights of law-abiding citizens, the same exact people that would prevent crime, would run into a building to save children, for example. Most of the gun owners I know are good, decent people. They possess a firearm. They own one for their own protection and for the mutual protection of their friends, neighbors, and the rest of our society. And the statistics bear that out. The fact of the matter is it's been studied over and over again how many crimes are thwarted just because people actually possess firearms. I argue all the time that in my district, there's a very low crime rate in the cities of Prospect and Wolcott, for example, because there's a very high prevalence of gun ownership. The fact of the matter is criminals don't go there to break in and steal things because the likelihood of running into an armed homeowner is much more significant. I really like what you mentioned about vaccines, Representative, because that is like a totally different world. We're used to a situation where companies are held responsible for the products that they produce. And that's right. If you manufacture children's toys and it contains lead or it's damaging or it can hurt a child or something like that, we should hold people responsible for that. If you manufacture a car and something goes wrong with the brakes on a series of of vehicles in a particular model, they have a recall, and they can be held responsible for that. That's perfectly normal. The situation with vaccines is crazy because here you are, they can't even be held liable for their actual product the way it is. And here in this bill, what we're asking is to hold people that manufacture and retail firearms to be responsible for their product, not when it's used correctly, but when it's purposely misused by someone, which is just an absurdity. How can you hold that responsibility over someone without even putting any guardrails to determine what that is? One of my fears about this bill is that while this state legislature continues to pass policy effectively erasing history, erasing criminal records and saying, it doesn't matter, your past life is irrelevant. On the other hand, we're telling gun retailers that they have to actually proactively discriminate against their customers based on their subjective view that somehow there might be a risk posed by making a sale. That, to me, is an extreme stretch. You cannot, as a legislature, put that on private citizens and an entire industry. It's unfair, and it's explicit in this bill. And, I understand the advocates who are coming here to promote this policy, from a safety standpoint. And many of the examples they use are quite reasonable. But I think in almost every one of those reasonable examples, there's already laws being violated and broken and a way to prosecute people for, violating those laws. This is creating an entirely different standard, an unachievable standard in my view, and one that I think is a tremendous stretch. And I'll just say one more thing about that, which is, the conversation that has been about accessories, for example. Every time an accessory was mentioned during the debate earlier today, it was always brought up that, well, that's not likely to happen. I don't think that would be actionable. Well, this particular legislation stems from the Bushmaster v. Soto case. And in my view, that is a lawsuit about suing a firearm manufacturer for advertising that in no way encouraged any criminal behavior or any type of negative activity at all, simply was celebrating the quality of their product. If that can be stretched into a viable lawsuit, then this bill, which is, in my view, 1,000 times more wide open, is going to mean a lot more damage to gun manufacturers and retailers.
I appreciate, it's one of the benefits to your knowledge coming before us, because the possible discriminatory aspect of a sale, I hadn't really even thought about. So I really appreciate that. If a gun seller is looking at two potential purchasers and the law puts the onus on them to scrutinize that individual even though government has approved of the transaction, that could become problematic because that seller may have an internal bias, right? And we would hope that that wouldn't happen. But, if I go to a gun store and, because, I've got the last name Fishbein, right? And people think I'm Jewish, but I'm not. I have Jewish roots, and that particular gun seller doesn't want, people with Jewish roots to have firearms, they could use this as a shield. I think that individual is going to do bad with that. I don't want the liability, even though the government has approved the transaction. So, no, I very much appreciate that because it's something I didn't think about before. Thank you, Mr. Chairman.
Thank you, Representative Howard.
Thank you, Senator. Senator Sampson, welcome back to the committee that you've been off for 4 or 5 days now. Mm-hmm. You said you could make some tweaks to this. Am I to understand if this were to come before you on the Senate, you may be able to imagine an amendment or two?
I might have a few amendments. I would probably start with the language about what a firearm is, what an unfinished frame or lower receiver is. Several years ago we had this crazy debate about ghost guns where at the end of the day the law that was passed really didn't define what a firearm is outside of intent. And I made a joke, I remember debating with Senator Winfield on the floor of the Senate, that I have a big giant boulder in the front of my house. And, is that a firearm? Yes or no? And the fact is that based on the wording of the bill, if I intended to break up that big boulder and pull the metal alloys out of it and turn it into a firearm, I think it could be categorized that way based on the language in the bill. That's absurd. And much like the discussion we just had about, what are reasonable controls, putting that on the firearm manufacturer and retailer is absurd. That's the role of the state government. The state government already establishes when they think it's lawful to sell someone a gun. A NICS background check, for example, or if you meet the age requirement, et cetera. We're already setting those parameters. So why are we going to add this new subjective and arbitrary parameter that effectively could get people sued? Do you think this person is a risk? Now you're putting that in the position of the firearm retailer. I think it's just a great way to cause litigation and put good and innocent people in harm's way.
When you write legislation here, which you do and you have for years, do you think the definition of firearm as defined in 53A3 includes BB guns?
That's a good question. I'm not looking at 53-A3.
Well,
I think it could.
I'll tell you that it's defined in statute as something that a shot can be fired from. The Supreme Court has heard a case this just argued last year in a home invasion, and they determined that an airsoft gun was not a firearm by definition because there was no CO2 cartridge in it. And that particular firearm had been wrapped significantly with like duct tape or something, and the court said that you couldn't reasonably get that thing to fire a shot very quickly, and therefore it wasn't a firearm, which would lead me to wonder if there was a CO2 cartridge in it, does it fit the definition of firearm? I don't know if you have an opinion on that court case or how we define it, because firearm, it just says here, firearm is defined in 53A-3, and I'm just wondering, do you think that could include BB guns?
Through you to the good representative, delighted to have our first conversation in this type of role as well, Representative. But based on that definition, I don't see how you could see otherwise. And I would also argue that's the danger of our court system. Our court system, when laws are presented to them that are not clear. In my view, we should write laws that are absolutely crystal clear. They apply to everyone equally, that anyone reading it is going to understand it very, very clearly. When we have ambiguous legislation, we say reasonable controls without specifying what they are, and we're leaving that up to a court, then a court's going to decide. The problem is that the court's not always going to decide correctly. They're going to make assumptions. They're going to make errors. I think that they erred in the Soto v. Bushmaster case by suggesting that somehow the threshold of violating our Connecticut Unfair Trade Practices Act was met by suggesting that somebody's advertising for firearms could be used, to advance that case. And I believe that the definitions that exist in our laws for firearm, and particularly unfinished firearms, I think are extremely broad and can be interpreted in 1,000 ways. A different court could have said that airsoft rifle was indeed a firearm. And I think you've indeed, as you mentioned, Representative, the door is now open to say if a CO2 cartridge is involved, like in most BB guns, it's going to be called a firearm based on that precedent.
So you've mentioned reasonable controls multiple times. You have the bill with you?
Yes.
So it starts in line 25, and you've said it's not defined. I mean, the bill does attempt to define. I think what you mean is it's not well defined, right?
That's correct.
So like if you look at line 27, right, prevent the sale, distribution of a firearm industry product to a straw purchaser. Do straw purchasers walk into firearm stores with a sign that says I'm a straw purchaser? I mean, how is a gun shop owner to know someone is a straw purchaser?
This is a perfect example, Representative. If they had said to someone known to them to be a straw purchaser, then that might be something legitimate to put in this bill. But as you pointed out, straw purchasers do not announce themselves typically. And we're having a major debate about lawsuits involving the Mexican cartels right now, suggesting that somehow there were straw purchases being made in the U.S. that are funneling guns to the cartels. And I think there's new evidence coming out every day saying that it was actually the Mexican government that was purchasing those weapons. Were they, in fact, the straw purchaser? And how could you hold a gun retailer, in the southwest of our country responsible when they're selling to a government entity? So again, putting some legitimate framework around policy definitely makes a difference. And when you hold somebody responsible to selling to a straw purchaser without also requiring that they knew it was a straw purchaser, for me is a non-starter. It shows just another way to put people in the crossfire and make them guilty even when they're completely innocent.
Well, the legislation, as I read it, doesn't, to your point, it doesn't require that they somehow knew, but in fact, in line 82, it says there shall be a rebuttable presumption that the firearm industry member failed to implement reasonable controls if they did certain things on here that seem to reference back to this section. And you agree that's a problem? I mean, we're creating legislation and telling the court that we're basically, if this suit comes and the firearm dealer, we're putting them in a less starting point, right? Don't you agree?
Yes, it's a circular argument in the bill. In lines 80 and 81, it says, in an action alleging that a firearm industry member failed to establish, implement, and enforce reasonable controls, it goes on to say there shall be a rebuttable presumption. And then it goes on in line 87 and 88 to say that they could have established and implemented and enforced reasonable controls. I mean, again, it never defines what those things are. That would be left up to a court at some point in the future. And I'm not confident that a court's going to get it right. I don't think they got it right in that Soto case. I don't think they got it right with the CO2 cartridge. And I don't think that they're going to get it right either. I mean, sad to say, but I've seen far too much political activism in our courts in Connecticut as it is. I don't want to see any more, and I don't want to send them laws that leave this building that are incomplete, that give them the power to interpret what is acceptable. I think we should do that on our end. That's our job, to write clear laws that apply to everyone in a very equal manner that people understand.
And staying back in that same reasonable controls definition here, it also talks about that they have to prevent the sale to a firearm trafficker. Now, we worked together on firearms trafficking laws a couple of years ago, which is a C or B felony. Would you agree with me that that's already an existing law, that you can't sell to a firearms trafficker?
Yes, without a doubt.
Because a firearms trafficker, you know, we talk a lot about due process here, and to be called a firearms trafficker, one would assume you must have been convicted of firearms trafficking, which is a C or B felony, which is already a disqualifier, right? And then the other question I wanted to ask, because, you know, I know you follow this stuff pretty closely, and Rep. Dubitsky talked about this at length with a previous person. In line 57, it says promotes a risk to public safety. Would you agree with me that risk to public safety is extremely broad, ambiguous, and subjective?
Yes. In fact, when I first saw the language of the bill, that is the very first thing that I highlighted that stuck out to me. Because who's to determine what a risk to public safety is? Certainly, in this particular case where you're asking the manufacturer or retailer to be clairvoyant, they would have to know that in advance. And maybe they couldn't possibly know that. Maybe they're selling a firearm, as was mentioned, many examples today, you know, someone that was depressed, that was going to commit suicide. I mean, how could you even put that on the gun store owner to make a determination like that? Hey, you know, they're not, I mean, are we going to be providing, government-funded training for gun store, the counter guy there to be able to diagnose mental illness? It's an absurdity. We are responsible in the legislature to put together, again, I mean, I hate to repeat myself, but laws that are clear, that people can follow. I don't think that you can follow this law as a gun manufacturer, and certainly not as a retailer. I think it's even harder for a retailer reading it without making mistakes. You're either going to engage in discriminating against people you shouldn't have, or you're going to let people slip through the cracks, because there is no definition that you can find in the bill. And again, I mean, it's absurd to even put this on someone as if, constituents across the state and people that are in this industry are going to be able to go through this bill language as we are today and have a full grasp of what they're supposed to do.
You've been on the Judiciary Committee for a long time. You've heard a lot of testimony. I'm a police officer in my day-to-day life, as you well know. How many people have come before you in the Judiciary Committee and testified that my existence is a risk to public safety?
That's a good question. A few.
The point is, it's subjective, right? It's up to an individual's interpretation as to what a risk to public safety is. I think there's a lot of people who say that police officers present is an asset to public safety, but there's a lot of people who think it's a risk to public safety. That's sort of my point. Jumping down to line 66, a person who has suffered harm. You've read a lot of legislation. You've written a lot of legislation. What does harm exactly mean? Because people are harmed by words, people are harmed by signs, people are harmed by other people's thoughts. Do you have concern over the word harm?
I think it's a broad term. I know for certain it's not defined in the bill. I don't know if it's defined elsewhere in statute. but I think that it could be used in a court to mean a whole lot of things. It could be you were harmed financially. It could mean your ego was harmed, for crying out loud, as far as reading the plain language of the bill. You know, without definitions, without clarity, I think that you're creating a environment that is completely hostile to this industry.
The next line, 68 to 69. So this is talking about who can bring action, right? And it says the corporation counsel or chief legal officer of a municipality in the name of the municipality can bring action. But it doesn't seem to indicate that anything must have happened. So does that mean that a municipality who feels that a firearms owner is not doing things the way they want them to do it, they can just sue him?
I think there are a few other requirements in the bill, to be fair, before a municipality could go forward and have a legitimate case. But I don't think it would take much for them to have a legitimate case under this bill because of its broad definitions. But it does beg the question, why is that in there? It doesn't make a whole lot of sense to me. If you're effectively, this bill says that a person that was harmed, quote unquote, as we discussed, a municipal leader and the attorney general. Those are the three entities that are allowed to bring an action under this legislation. And I mean, we've seen this before. I mean, this is effectively using the force of the state government or a municipal government to infringe on the rights of people that engage in a perfectly lawful industry. And we've seen this over and over again, that folks that are Second Amendment advocates, people that manufacture and sell guns, in my view, they don't have the same rights as people that sell other products. They are forever behind the eight ball, having to defend themselves. And this is just another and very egregious example of that.
Senator, I appreciate you being here. I appreciate the way that you go through these bills. And I have great trust that out of 109 lines in this bill, should it see the floor of the lesser of the chambers where you reside, there's probably at least 109 amendments. So I would encourage my colleagues to be prepared for that. Thank you for your work. Thank you, Mr. Chairman.
It's my pleasure.
Thank you. And thank you for joining us again. I didn't recognize it was 5 days. It feels like you were here just yesterday. I mean it that way. So thank you very much, and I would encourage, if we are serious, since you have the knowledge you have, that I would consider the amendments. So hopefully that comes earlier in the process rather than later when there's very little that we can do about it. Having said that, it is good to see you, and thank you for joining us today.
Thank you very much, Mr. Chairman. Much
Okay.
appreciated. Thank you.
Absolutely. Okay.